and ask the court not to consider opinions that don't meet the reliability test, because he refused, expressly refused, to look at the objective data.
Well, if this were a traditional jury trial, the court could hear the testimony in camera, make that determination before a jury were to hear it. So I got to hear it all at one time, and if I support your argument, then I will not rely upon it in my decision making.
Very good.
Simple enough.
Thank you very much.
It's simple enough to say, it may be difficult to apply.
I understand.
All right, we ready to go?
Yes, sir.
All right. Sure. We need to take that board down so people can see from the other side.
I just,
I've been working off of 3, haven't you? I did go too long for lunch. Am I gonna get Mary Catherine over there?
you might have to. Let Morgan do it, Judge. Morgan.
What's up, man?
Enough. This opinion anyway.
Huh?
That's probably enough anyway.
I think it's enough. You hear one expert for them all, said the argument. I heard that work sometimes.
Oh, Judge, we got on Netflix on the other ones.
Mm-hmm.
We shouldn't have taken them.
No, no, she went right on through.
We'd be going home by now.
This is why I like all the papers.
Backup plan. Y'all done an excellent job of tag teaming the electronics. You've done a good job. Very, very, professional. Technology's come a long way since I started practicing on.
It's not killing.
This is a sign. This is a sign, a hint. Somebody jinxed us.
Y'all want to get this straight, I'm gonna get up.
Boy, you stay right there.
My screen just blank like it always has. Let's just watch the next one.
Put Seinfeld on. No soup for you.
Hands laptop, what do you do?
I mean, we can do that. It's been done before. Sometimes people even call live witnesses.
I would have, because most of them find out.
That's long walks. They won't know any better. I mean, I got the best two, maybe not.
I got a wire machine on this as well.
I got it.
November, I need that. Hospital. Cynthia, I want that on the record. Mary Catherine is the solution to that problem. We had too many boys on it.
That's. You always need
Randy,
that
you did good
woman's
too.
touch. You need the woman's touch.
Apparently.
A recorded and video conference deposition of Robert C. Maher, PhD, PE, taken in the Court of Common Pleas, 15th Judicial Circuit, State of South Carolina, County of Horry. Case number 2024-CP-26-03798. Jennifer Spivey Foley as personal representative of the estate of Scott Ryan Spivey versus Charles Weldon Boyd and Kenneth Williams. Today is September 8th, 2025. The time is 12:55 p.m. Mountain Time. We are present with the witness at 608 Cobley Hall, Montana State University, Bozeman, Montana 59717. The court reporter is Deb Favorites and the video operator is Bridger Arthen of Fisher Court Reporting. The deposition is being taken pursuant to notice. I would now ask the attorneys to identify themselves, who they represent, and whoever else is present. For those attending remotely, please note from where you are appearing.
So Mark Tinsley and I represent the plaintiff, the Spivey family.
This is O'Brien Martin, I represent defendant Kenneth Brandon Williams.
This is Kenneth Moss, I represent Charles Weldon Boyd.
Okay,
Robert Lee, I represent, Mr. Clark, same defendant.
with that, the court reporter will now administer the oath.
Would you raise your right hand, please? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good afternoon, Dr. Martin. Would you tell the court what it is that you do for a living?
I'm employed as a professor of electrical and computer engineering at Montana State University.
And how long have you been employed here?
I've been at this university since 2002, so I'm starting my 24th year here.
And for the jury's benefit or the court's benefit, where are we today?
We're in Bozeman, Montana, on the campus of the university.
And
Spoke to somebody on this side and it seemed like they had a thumb drive of some type that had all the exhibits on them, or something similar, maybe all the audio records would. Am I correct in
It's the
thinking?
same stuff we got, it's the same stuff he got, but we'll hand it, it's got our exhibit numbers on it, we referred to them, so.
But is that everything? And what he's speaking of is the same deal, everything?
Yeah, there's nothing different.
But there were a few additions.
We don't think so. I don't know what he's got on there, but I don't think so. I mean, it is, the case.
And those won't include will be the two things just added in the end.
And they could be on Mr. Davis' slide film there, although they're not included by numbers.
Yes.
So they're on there, but the numbers, they're not identified by numbers, they're marked.
Yes. Yes.
Judge, what I'm saying is, just like in the Mr. Boyd's testimony, all the actual telephone calls, if at some point, some other court wants to hear these calls that are cited in our brief, the actual calls are going to be here available in the court record. You've got access to them already through a link, and so that's what I'm talking about.
Fair
Yeah,
enough.
he's right. What I've got you does not include those recorded phone calls.
All right. Those will be supplemented. Last exhibit defense, last exhibit plaintiff, for purpose of this record.
Thanks.
Whatever those numbers are, Cynthia will tell us momentarily.
Yeah,
As long as she knows which number they are, we can find them.
this would be defendant 67.
It's gonna be 70.
70, sorry.
70%. And Plaintiff is 24,
Plaintiff's 24,
defendant is 70.
70. Okay, so the thumb drive and the SD drive will be respectively 70 and 24.
Yes, Your Honor.
All right,
Thank you.
very well. All right. Y'all have asked for brief summaries. I think 10 minutes each is enough. That's brief.
How about 15, Judge?
Well,
Can't clear his throat in 10 minutes.
my gut tells me to do what I want to do. So,
That'd be 5 then, right?
I'll take his other 5.
no, if I just do what I want to do, I'm not going to hear from y'all again.
Don't do that.
But I mean, as y'all know, the lawyers know, this has been a lengthy hearing for Stand Your Ground. It's been 4 days, and a full 4 days. It's not been downtime doing things you do during a jury trial. Things happen. But the end result is we're going to get probably 2 different orders, one for each party seeking immunity. And those have to be drafted up and eventually submitted to the court. And after those are done, then there's going to be motions to reconsider. So, I'd rather not have closing summaries because of all that follow-up. This is not like a criminal court where there's no motion to reconsider. Criminal civil court has motion to reconsider, which can adjust, correct, modify findings by the court or omitted issues the court didn't address.
I hear you, Judge, but I would ask you to give us, whether you call it 5, 10, or 15 minutes, to say a word or two.
All right, I'm gonna give in. Y'all the moving parties,
Yes, Your Honor.
y'all go first.
And we have agreed not to be duplicative, but our clients are a little bit different situated.
They certainly are.
Your Honor, I want to talk about the elephant in the room, okay? This case is really about the phone calls because the evidence, the relevant, probative, reliable evidence for what the witnesses said and the way this case has come out, it's the best evidence because those witnesses had outside pressures and they've been influenced. There's no question Mr. McMurray's been influenced. We played his on-site interviews right behind his deposition, slightly different. Blaze Ward, no question. She said facts don't change, opinions do. Well, her opinion doesn't matter for the purposes of what the court has to do. The facts do. And she confirmed the facts. But let me say, the phone calls are the elephant in the room, and nobody in the courtroom, other than my client, said the out loud part. They're disgusting. My client said they were disgusting. A lot of us probably thought it, but he's the only one that said it. They are after a traumatic event. They are after a time when my client was in a harmed state. He certainly had a crash afterwards, which he explained to you. And I submit to you, while they're horrible, they're not relevant to this case. There's no admission in them. There's no intent expressed with them. There's no design expressed with them. And so I feel that we need to address that. And that really is where Morgan's client and my client, or Brian's client and my client differ. My client, of course, was driving. Their client was not driving. But the phone calls are why I think we're here. And I would ask you to be very cognizant of that, Your Honor. And as far as Maher goes, the witness we just heard from, very impressive engineer. He and I talked about both being engineers when I was there. They hired the right man for the job, but he didn't do the job. He didn't lab it. He didn't know what kind of firearms they had. He didn't know what kind of vehicles they have. He didn't know orientation. And ultimately, he said, I don't know, because he didn't hear the gunshots.
He said exactly that.
He said he don't know. And so I don't know that he adds anything to the court's consideration, but I will defer to Mr. Anytime I have left, I will yield to Mr. Martin so he can talk about the evidence in the case to the extent he can.
Thank you, Judge. Please, the court.
Yes, sir.
Doesn't matter to you where we stand, though.
Say where you're coming from.
Okay. I am going to make this abbreviated. You'll be happy to hear. Okay. But there are some things that I do think are worth mentioning, and I would like for you to take with you when you leave the courtroom. First of all, there's a lot of uncontradicted and/or facts that are overwhelming, I believe. I don't think there's any question in this case that Mr. Spivey was at Boardwalk Billy's drinking. We knew blood alcohol was what it was. He got on Highway 9 and he drove horribly. He started at Bell and Bell with Blaze Ward, pointing a gun, elderly couple forced off the road, pointing a gun, drives on up through until he does encounter Weldon Boyd's truck that Bradley is riding in with him. And I would note there was no 9-mile chase. For what that's worth, I've heard it so much, I want to say it. No 9-mile chase. That chase, if you want to, and we'll call it a chase if that makes everybody feel better. But it was 5 miles or so, and actually probably 3, because what you had was the 3 or 4 miles before they ever saw each other. You had 3 or 4 miles, maybe 3 miles, where there was interaction between these two vehicles, and then a couple of miles where there was a following of Mr. Spivey's vehicle to Camp Swamp Road. Now, there's no question that the initial aggressor in this, and we're talking about self-defense, was Mr. Spivey. No question about that. Now, what the plaintiffs try to say is, well, or at least the way I read his brief, and the question is, well, he was withdrawing. He withdrew. The law on withdrawal is pretty clear too. And there was no withdrawal in this case. There was no communication of that fact. If I guess what the withdrawal would be, well, he sped away a certain distance, and then he turned on the Camp Swamp Road. But the law is there, and we've given you a more recent brief here recently, today as a matter of fact, that what he did is the case law would call is a bit more of just a cessation, but not a withdrawal, a temporary retreat. He sped away in Mark's brief, and he's a great lawyer. Mark's brief talks about the withdrawal and the reasonably calculated unlawful move that would take away one's right to self-defense. That's what he claims here, because then you're at fault in bringing on the difficulty. But in this case, I would say that that's exactly the opposite. First of all, never communicated his withdrawal. In fact, when he turned off the road, as they turned on, when he turned off the road, as they turned on, he stopped. He jumped out with a gun, abruptly, yelling, waving. That's not a withdrawal. If you want to talk about a move that's reasonably calculated to cause trouble, that's it. That's it. He's not scared. If he was scared, frightened, he would not have stopped. Or at least it seems to me that that's a reasonable interpretation of what happened. He had been controlling this whole situation the whole day. As the old Law Malice used to say, he was a guy who was devoid of social duty and fatally bent on mischief. And that's what happened. If you want to get down to why this happened, he caused it. His fault. He didn't withdraw, not under the law of the state of South Carolina, and you can read that, and I'll leave it alone. Now they say, well, when Mr. Boyd took off after him, followed him, pursued him, chased him, whatever you want to call it, that, well, when he did that, then he became the aggressor and somehow lost the ability to claim self-defense, because then he's at fault for bringing on the difficulty. That's not what happened. I do want to say, first time I saw this law was in this case. But the law in South Carolina is common law, that is, that from the earliest times, English common law has placed a duty on every person who saw another commit a felony to apprehend him or make outcry, calling the community to pursue and take him. This duty remains an important feature of Anglo-American law in the modern day. Any person who views a felony has a duty to arrest or to call others to his aid by seeking an officer of the peace. That's what Mr. Boyd, and to the extent he had any role in it, Mr. Williams did. You got the 911 call, listen to it. They wanted to shoot him. He gave him a reason and a right, most likely, to do it on the highway when he puts the gun out the window at him. So in that case, and in State versus Dickey is another case that I would encourage you to look at on that same idea, where it talks about whether you're doing the right thing or the wrong thing. That speeding, whatever the speed was, is Mr. Tinsley's brief says, the speeding, assault with a vehicle, reckless driving is an unlawful act. And he says reasonably calculated to bring on an encounter. Thus, they lose their right to argue self-defense because they're at fault. Because he knows that's the only reasonable chance he's got. Because I'm going to talk about just briefly, just a second, what happened on Camp Swamp Road is a classic self-defense event. Whether you like it or don't like it, it is. It is. So that thought that, okay, somehow Weldon Boyd, by doing what the law says he ought to do, Mr. Tinsley is a really good civil lawyer, I'm told. This is my first time in court with him, and he's a good lawyer. But it says there's a duty. So, Mark, it got me to thinking, let's suppose that Mr. Spivey did travel on down that road, and he didn't stop, and nobody stopped him. Nobody tried to stop him. Nobody tried to call the police. He gets to the next intersection, does one of two things. Drunkenly runs through that intersection, kills 3 people. Or something that was at work with him that day finally snaps and he shoots somebody. Maybe under the law, common law duty, you could sue Weldon Boyd or another motorist for not doing anything. You got a duty to call somebody, a duty to do something. And here, so where are we in this world if you do that, and then all of a sudden this happens, and you ain't got a right to self-defense. You broke the law. What a horrible thing. They chased him for 9 miles, which ain't true, but give it to him. But that's foolishness. It's foolishness. Now, if you go on past that, the question would be, okay, did he take off after him just to kill him, just shoot him? That's it. I'm mad with him. I've had enough. Just gonna take off and shoot him. Well, I would say to you, Judge, that again is not what happened. They called 911. They asked witnesses to stay at the scene. They were trying to get officers there. The dispatcher did tell him, okay, get us some information. That's what's all this about. So I'm going to lose my right to self-defense because I do that. Shouldn't have turned down the road. Well, why? What's unlawful about that? Nothing. Nothing's unlawful about that. And between State versus Dahl and State versus Dickey, the idea that they have no right to call the police and try to get somebody, this guy, is ridiculous. I feel it is. And, you know, Abraham Lincoln, it said, would tell a story about a dog and his tail. So he's telling the audience, said, listen, if a dog has 4 legs and I call his tail a leg, how many legs has he got? They would reply 5. He'd say, no, 4. Calling his tail a leg don't make it one. And calling this a unlawful chase don't make it one. And calling it a act reasonably calculated to bring on this fatal encounter don't make it one. That's not what it is. Now, what happened here, when you get down to the roadway, I think all the evidence certainly points to the fact that Bradley Williams and Weldon didn't want an encounter. They wanted to keep an eye on. You heard Bradley say in the video, 911, back up Weldon, and the explanation that they didn't want an encounter, didn't want to get close to him. And then, but they get there, and when they make that turn on the Camp Swamp Road, he has stopped. He stopped. He's brought quickly. And he gets out with a gun. Not a white flag, not a surrender, not a withdrawal, but a continuation of a pattern of criminal conduct that started at Bell and Bell with Blaze Ward. From the moment he jumps out with that gun in his hand in a hostile manner, it don't matter who shot first. It doesn't matter who shot first. State versus Hendricks, which I know you're familiar with over the years, and State versus Dickey and State versus Starnes all make it crystal clear that you don't have to wait for your adversary to get the drop on you before you defend yourself. Now, who in this room that had been in the place of Boyd and Williams would not have been scared for their life when they had witnessed what they witnessed on Highway 9? And then he stops abruptly, jumps out with a gun, a loaded gun. Not to mention a small arsenal in the back of that truck that he did not get around to firing. Okay? From that point on, that's self-defense. Of course, the testimony you've heard, and they're trying to refute it, is he did aim, point, shoot first. I believe that evidence is not only by a preponderance that that's what happened, it's more than that, but all we have to establish is that by a preponderance of the evidence. Now, the evidence you got is what Weldon said, what Bradley said. Of course, somebody said, well, they're not telling the truth. They lied one time, so they lie every time. Well, you and I know that ain't right. And there's never been a murder case, criminal case in Horry County or all over South Carolina or probably anywhere in the nation that there hadn't been some sloppy police work and some things are missed and they don't pick up something they should and it doesn't take a photograph. Now, in this case, they're trying to say that he didn't fire first and that it was at least Weldon Boyd's intent from the beginning to murder him. And as proof of that, they say, well, there was only one shell casing in the roadway. Well, there was one. Nobody said he shot a dozen times, but there's one. Well, it might have fell out of the truck. Well, maybe. You know, maybe the South Carolina football team win the national championship next year. But there's a shell casing in the roadway. There's 10 in the 9, 10, 11 in the truck. Then they say, well, Mr. McMurray, he's going to save us here. He gave a statement and he tried to back up on it, and you got the deposition, but he got himself confused. But at the end of the day, you take all of his testimony and you take it together. What he says is, I'm coming down the road, black truck abruptly stops, guy gets out with a gun in his hand. So their witness, Mr. McMurray, got a gun in his hand. And he's not walking towards Mr. Burrow, nor he's not walking over to the ditch to shoot a snake. He is going back towards that white truck, yelling something. No withdrawal here, looking for more trouble. Sadly, I say that sadly because this is a sad event. From what I can hear, see, learn, Mr. Spivey was a decent young man. These are decent young men. But on that day, for reasons satisfactory to himself, Mr. Spivey was he was in a bad way. But McMurray said, I come by, he jumped out, I see him, he's got the gun in his hand. And I look up and I see, he said he sees what he thought certainly was Mr. Boyd with a pistol over the dash. He drives on that 75 feet, 25 yards from Spivey to Weldon Boyd's truck. And it takes some period of time to do that. Is it 2 seconds, 5 seconds? I don't know. There's probably some expert somewhere to give you an opinion on that. But at any rate, there's a period of time, and he says that he drives by, and by the time he gets in what he sees of Mr. Spivey from that point on is through his rear view mirror. And he's trying to drive, and he's trying to look at Weldon Boyd, and he's trying to get his wife pushed down. He don't know what the hell happened, to tell you the truth, but he's trying. He called 911. He knows his social duty. And then he says at the end of the day, I don't know who shot first. And they're going to say, well, he said he heard all of a sudden all hell broke loose, bap, 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 to indicate somehow that means that Mr. Spivey did not shoot first. It don't mean that at all. That is no evidence that Mr. Spivey didn't shoot first. There's a shell casing in the roadway, indicative of one thing and one thing only, that it was shot outside the truck. I don't care whether it's by the tire or on the side of the road. When you got that gun up, you're twisting around, and there's a shell casing there. He shot. But I'll tell you again, Judge, he didn't have to shoot for this to be self-defense. When he got out brandishing that gun, it would take an idiot not to think that my life is at stake here with this guy with a gun angrily moving towards me. Either way, these two young men had a right to act. Well, let me take that back. Officers don't have the right to act on appearances, but I tell you that they do, because they saw the gun here. I agree with that. So that means then they don't have to wait for him to shoot first, because you don't have to let him shoot first, because then you may not be able to shoot back and you're dead. Doesn't take a brain surgeon to figure that out. Self-defense, self-preservation is an instinct that comes from the gut. You got it, I got it, everybody in this room's got it. The great buck on the hill, mightiest in the woods and the forest, if he hears the snap of a twig, he's gone. He's not going to let trouble get him first. So, multiple shots, no doubt, multiple shots, whether it's 24 cases they found or 29 that the expert had, and I'll talk about him in just a second. You fire, you're taught, you fire well until the danger is eliminated, diminished, no longer a problem. And you heard the testimony of both of them. I know particularly well Bradley Williams, because I questioned him, that Mr. Spivey was able to get back into the truck. He did continue to fire, and I'll say again, according to Angelina Phillips, it is strikingly strange that the point of all places on his body where he hit is under his armpit, just to the back of it, so they can call it the back. But it's under his armpit, and it travels through his body, side to side. Consistent, according to the pathologist and to you as a bright, reasonable man, that's consistent with, he came out, he did at some point in time get that gun up at these young men. He shot, they started shooting, and I don't know what he knew about what they had or didn't have. I don't think he had any reason to know they had the guns they had, the firepower they had. But they start shooting, his arm is up, and he turned, I'm gonna get back in this truck, and one of those bullets that catches him right through there. He had the gun up. The physical evidence is he had the gun up, pointed at them when he was shot. He did make it back to his vehicle, carried on the fight, emptied the magazine that he had, and sadly, he died. Sadly. Expert's testimony here.
But don't worry about him.
Don't worry about that.
He didn't hear shots outside the truck. I got
Okay.
that.
All right. Judge, he started it. He never withdrew. They were doing nothing but trying to get help to get to him. If there was a lack of judgment in what they did, the law specifically says that that doesn't eliminate your right to self-defense and does not make you at fault in bringing on the difficulty. State versus Hendricks. It's all through there. And Hendricks tells you exactly what withdrawal takes. It's not what you got in this case. So I want to say, lastly, whatever kind of case they got here, there's one thing for sure. There's a marked difference between Bradley Williams and Weldon. And I'm representing Bradley. And I talked about the whole thing called Bradley, made Bradley part of it, and he did shoot. Okay, I don't know whether he's the one that actually shot the young man or not. But Bradley came down minding his own business. He was not driving. He was not speeding. He was not chasing, pursuing, following, or any of those things. He did not turn down Camp Swamp Road. He was not looking for trouble. He said, slow down, Weldon, on the roadway. And when they got to the scene, and you can hear it in their voice, Judge, you can hear it in their voice. They're scared when they turn down that road and they see him with that gun. And what does Bradley say? Back up, Weldon, back up, back up. They tried to retreat. No duty to retreat in this particular situation. But that's what was on their mind, not killing him. If they wanted to kill him, they'd have drove right up to him. Right up to him, took that pistol out the window and shot him. That's not what happened. They weren't looking for trouble. But I hate to say it, but Mr. Spivey apparently was. So, again, I appreciate your time. I tried to do it as quickly as I can. But obviously, this is really important to a lot of people, and I don't want to not do the best I can for Mr. Bradley Williams. He's a fine young man. Thank you, Judge.
All right. Ms. Tinley, I want you to stay there. I've listened to this whole thing, this withdrawal or trying to get away from the thing. Driving over 115 miles an hour trying to get away sounds like a reasonable trying to withdraw. I don't know what else you could have done to get away from there. That's getting away, that's withdrawing. At least that's indicative of it to me, and it wasn't working. Anyway, this is immunity here. Not a guilt or innocence. It's not a money thing. This is immunity. And this not in fault and bringing on the difficulty, that's a tricky, but credibility is huge here. I'm evaluating credibility of what I heard. And preponderance is 50-50 plus a smidgen. Y'all got to get the smidgen more to meet the preponderance. I really question the credibility of Weldon Boyd. I find his testimony lacking credibility in many places. I'll give a few, for instance. I'm not going through them all, but a few. He called Mr. Strickland a deputy, but he wasn't looking for help. He called a lawyer looking for help. I get that. I called the chief deputy, but it wasn't looking for help. It's not credible. The differing descriptions of Spivey's behavior outside the truck. Compare McMorrow's description to these two's description, totally different. I don't know how you confuse those. Even if you're looking through your rearview mirror, you can see a big difference. Now, whether you call it pursuit, following, I'm chasing, they know. Both guys in that truck know that the guy they're following at a rapid, trying to keep up, has got a gun. Stay back. He's acting like a fool. He was. Spivey was acting like a fool that day. No question about that. But foolish behavior don't require you to foolishly act yourself. And it seems that driving over 100 miles an hour trying to keep up with the guy with the gun is foolish. So the Spivey speech, y'all got me 1 second intervals all the way down that road. And somehow the Boyd truck was able to maintain its close proximity to give a pretty detailed description to 911 once he was giving a description to 911. Anyway, I find it incredible. The testimony of Williams, still balancing that. He's got better credibility than Boyd. Phone calls Boyd made after the fact shows his, I don't know, trying to get his story straight maybe. Trying to get help, trying to make certain that they're gonna be free and clear of any responsibility, liability, whatever the word you want. And he's certainly communicating to Mr. Williams to get help in that regard. So here's what I want. I find that Mr. Boyd's request for immunity is denied. I'd like a proposed order to that effect. I'm still sitting on Williams. He didn't want to be there. He said, back up, slow down. He tried, but yet there he is. So he had no way of not following at 100 miles an hour and keeping up. I'm not certain how to sort that out. I'm going to study that one. So I'd like a proposed order from you and from whichever one of y'all, 3 of y'all, I don't care which one writes it, from the team. Proposed orders respectively, granting immunity, denying immunity. This one's, I want 2 orders from you, 1 order from you. And you know, y'all asked me several times, I want to hear the 911 tape again. The last time I heard it, this is, I don't know exactly, but it wouldn't take much to convince me the last word's on there. Mr. Boyd was backing his truck up. He said, backing up, backing up, backing up, removing himself away from the truck at the scene. I don't know whether he did it or not. Nobody addressed that, but it sure is on that recording. pretty incredible statements when he's excited, reporting what he's doing. But the last three things he said, backing you up, backing you up, backing you up. And that was after Mr. Williams said, why did you have to keep doing this? Said at the end, I don't know whether they moved the truck or not. Well, it doesn't have an indication or an impact on my decision to deny an immunity, but it certainly could be argued. All right, am I clear on my instructions?
Yes, Your Honor.
Yes.
Clear? Clear?
Yes, Your Honor.
Good deal. All right. Now, I want y'all's orders to be turned in the same day. I don't want y'all to read each other's and respond to it. Prepare your own orders.
How long to do that?
About 2 weeks. Today's Friday, Friday in 2 weeks.
Yes, sir, Your Honor.
About noon,
Sir?
noon, Friday, 2 weeks.
Yes, sir.
Perfect. I like it. Mr. Moss, you file all the orders, motions you need to, because I've ruled against you and I understand.
Very well.
You just, I know you know the rules very well. So nobody's restricted. File the appropriate motions. All right.
Thank you, Your Honor.
Thank you, Your Honor.
That concludes our hearing.